Welcome to the American Intelligence Media. I am your host, Thomas Paine, and the ass of the globalist, also known as Douglas Gabriel. And today, my guest is Michael McKibben, and he is going to, unfortunately, rock my world. I have to give a retraction from something I said because I'm bringing Michael McKibben, who is such a good researcher into legal issues, onto the show today, and he's going to demonstrate that something I said was wrong. Welcome to the show, Michael.
Hi, Thomas. Glad to be here.
You know, I came back after not paying attention to the news for a couple days, and I read that these three judges had looked as if they supported Donald Trump, the president, and didn't support Mueller when Mueller came before these three different judges over the issues of the special counsel investigation for Manafort and also another one over some other issue. Anyway, the point is that we're going to talk about those three judges today, and I was misinformed. I had read something in two places that said two of those judges were Trump appointees. Only one of them is. I would like to retract that. So I thought for a moment that maybe two of the three might be doing something good, and I couldn't understand why Judge Ellis, who I know is completely corrupt, old-time corrupt, why he would possibly be on Trump's side and actually be doing some justice in our most corrupt and rigged federal court system. Because as we know, when you get sent before a federal judge, you know what the outcome is going to be before you get sent there, because they're all corrupt, they're partisan, they're biased. That's how they got there. That's the way that it works. So can you please explain to me, Michael, because you have, but I want to make sure that this is explained again so I understand it. Why is it that these three judges look like they were on Trump's side, but you know for a fact that they aren't, and you actually have a speculative theory about what they're really up to? So can you tell us about that?
Yes. My head's kind of swimming because we are getting so much research from our researchers right now, and a number of us are reading as fast as we can. So this is kind of hot right now and off the drawing board. But what I learned years ago was that as I can't think like an engineer when I'm looking at things that lawyers do, because engineers are used to looking at facts, they're used to building things, solving problems, and moving on with life. And one of the things it took me a number of years to get over that cognitive dissonance if I don't see that kind of behavior among attorneys and judges. And I think I'm beginning to figure a few things out, and that what used to seem illogical and immoral and unethical to a lawyer when you actually get into their world is quite logical, and among themselves they accept this alternative reality. And one of the things that I was told way back when we sued Facebook for patent infringement is that you really couldn't accept, or you couldn't listen to what a judge said and read whether that judge was favorable or not to you going forward. And I never quite understood that, with the logic that if you're speaking truth, you're going to continue to carry that truth forward. But what I've learned is that judges often, and lawyers, often make statements that seem completely opposite to the position they actually hold, and what that does is that throws off their opponent. And I think that's what's going on here. The first twinge to me that something was wrong with all of a sudden these three judges coming out in statements that seemed to be favorable to President Trump isn't that an odd coincidence that not one, not two, but three federal judges would make statements literally within a 24-hour period? I don't know exactly when each one made their statements, but it was very quick, and all of a sudden they seemed to be taking the opposite position. And what our researchers have been doing is digging into the backgrounds of these judges, and I can tell you with 99% certainty that these are all deep state plans, that all these judges were put in the positions they're in now because their pedigrees betray them. and their pedigrees are such that they can't be anything but deep state. So therefore, if they are now making statements that seem to be positive to the president, what is probably going on is that is a misdirection, that is a bone to throw to the supporters of President Trump to keep them off of the hunt and to deflect away from what is really going on and what they really intend to do, if that makes sense.
Oh, absolutely, that makes sense. Not only that, but you have now pointed out with some degree of speculation of what exactly the plan truly is. I thought it looked as if this was going to be the plan, or not a plan, but that it was going to close down the Mueller special counsel investigation because basically it is on the wrong footing. And we noticed from the beginning, first off, there were leaks every day. Okay, every time they did something, there were leaks. That should have immediately compromised it. There were judges involved who should have recused themselves. Most of the lawyers involved on the Mueller side should have recused themselves. They come in and they give Comey immunity, obviously, by the 40 questions that they just presented to Trump to answer. So Comey gets immunity. Comey's the criminal who led the impeachment investigation. Now these judges are saying that this is an impeachment investigation and that it has continued on from the George Papadopoulos and that they want to see unredacted documents. This made my heart leap for joy. But when we see that that's happening and it looks good, we should also realize there's another door going on, and that's the back door, the golden parachute, the way that Mueller's going to get out of this. Can you tell us about that?
Right. Yeah. The way court cases get presented is that you make claims, and then the court, by law, must accept your claims as what's called well pled. In other words, accepting that you are telling the truth and that these are valid claims, and so the case goes forward. That's true except for issues with regard to fraud. And issues with regard to fraud have to be what's called pled with particularity. In other words, you actually have to present the case evidence at the beginning of your claim in order for it to survive what's called a motion to dismiss or a summary judgment. And so the bottom line is you have to put your complaint out there with details of the fraud that you believe has occurred and how the person has done something wrong. Now, once you get through the case, once that a judgment is made in that case by the judge or a jury, that person can never be sued again for those same facts in that fact pattern going forward. It's a concept. It's not a concept. It's a law called re judicata. It means you can't be sued twice for the same claims. And so when you recognize, now most of us are lay people, we don't want to go to court. We don't want to be accused of such things because defending ourselves is expensive and it hurts our reputation and things like this. But that's thinking like civilians. When you think like lawyers, you realize this is their playground. They don't care about these lawsuits because if they've got the back office rigged through the chief judges and through their friendly judges, then they know that having claims put forward of them committing fraud can easily be done away with by just simply having the judge at some point during the case, which has probably been delayed for years, just decide to dismiss the case and under the doctrine of judicial discretion. So once that case is dismissed, all those claims of fraud and all that evidence of fraud is then brushed under the carpet, and that person can never be sued again on those particular facts. So from that standpoint, anything that comes up in these court cases, in these three judges, anything that's pushed into that case becomes a part of the fact pattern that if the judge then later dismisses that case under some cockamamie logic later on, then the person who was accused of that is then exonerated as if, they cannot be sued again for those same facts. Now that's my layman's interpretation of what's going on here. So it's a confidence trick, is what I think it is.
That's amazing. I would have never, ever, and none of the members of the conclave would have ever come up with a concept like that, because just as you say, as an engineer, you approach it with logic. That's not going to work here. You have to approach it with a mindset to understand the rig system, to see where the deceit is, the subterfuge, really, it's kind of judicial espionage, isn't it? And if you know these judges, and you know the chief judge, and you know who the case is going to be appointed to, then you can know the system. So what you're saying is, all three of these cases...
Or you tell the chief judge who to put in place.
Exactly.
It's worse than that. It's not if you know them. It's you probably got them put in place. So you, in fact, just call your buddies behind the scenes, and we say, we want XYZ judge on this particular case. Wink, wink, nod, nod. Thank you.
And generally, they should recuse themselves for that, for being associated with the people or in previous cases or so on and so forth. But it seems as if that doesn't matter whatsoever anymore. So these judges are appointed, and they are linked to the very people that they're supposed to be meting out their justice to, which shows that they should have recused themselves. There's even collusion there. There's cronyism. There's the worst types of rigging. And so what we're seeing in these three cases is not that Trump is winning. It's possibly that the investigation is coming to an end. And this is the way, as you've pointed out, through the fraud charge. They're hoping, like Comey was hoping, to get fired by Trump so that he could have a special investigation to give him what? Immunity. He has immunity. Mm-hmm. So what does Mueller want? He wants all of his activities as part of the special counsel and previously, whatever they might throw at him, to be put into a big basket and to be swept into the area where no one will ever see it again. Oblivion, complete. No memory can ever bring those things up again. So what he's doing is exactly what we had predicted. We predicted he was coming in to exonerate Comey, to make sure that the status quo goes on. No one in the bureaucracy gets prosecuted. They'll go after some low-hanging fruit, and we even stated that they will not be able to prosecute them because they're going to go after Manafort. And Manafort is a big fish. He's not a small fish. He's the one fighting and causing some of this stuff to happen. He's going to fight it because he knows, and he may have known from the beginning, because of course he's friends with Mueller. We have to remember that the greatest opposition political groups in Washington, D.C. are Fusion GPS, Glenn Simpson's group, and Manafort's group. Manafort, Stone, Kelly, and Black, or however it is. They used to be the number one Republican opposition group, so they had to get rid of them. And so this is a political thing to begin with against Manafort. But we said from the beginning, Manafort has been investigated since 2004. Eric Schneiderman has gone down in flames, as we predicted he would go down. We also predicted that the cases in the Southern and the Eastern District of New York that were going after Manafort that had stalled when they opened the new grand jury in Virginia to subsume all of those previous investigations and records, that was completely illegal. That has nothing to do with anything that the special counsel was supposed to be looking at. And we also predicted, because the word conspiracy against the United States of America, the word conspiracy, and a charge, conspiracy against the United States of America, which doesn't exist, will never hold water, that Mueller will never be able to prosecute anyone. We predicted that from the beginning. This was just a political theater. This was just an attempt to besmirch the president during the election, president-elect, and the president, and it continues on. And the judges, when they said that this is a continuation of the George Papadopoulos counterintelligence operation, not an investigation, an operation, a counterintelligence operation against a sitting president still going on under the auspices of a grand jury indictment, fake special counsel Robert Mueller, he has to cover all of his trails. They have to cover up, he came in to cover up Comey's trails and McCabe's and all the people involved in the small group, the Trump impeachment operation, all the different names, the secret society. They had many names, and we're the only people who kept calling it all those names and including the Mueller investigation, because we said from the beginning that as far as we know, the Mueller investigation against George Papadopoulos has not ended. There's no indication it has ever ended. And remember, they didn't even investigate the situation until 1 year later.
Well, here's the useful thing.
Mm-hmm.
I'm sorry.
So it's the useful thing that Mueller was doing, but it shows the corruption from the beginning.
Useful to have judges involved. The reason it's useful to have judges involved is because a judge has discretion to stretch out a case as long as they want. So they could drag it out for 2, 3, 4 years if they wanted to. So there's a lot of room to play just by having issues in a court, especially if you control the court. And so you can dial that judge up and say, we need this to delay for another 6 months, 2 years, 3 years, whatever. Just figure out a way to do it. And these judges that are in their pockets will do it. Let me give you an example. This T.S. Ellis III, who was in the Manafort case,
yes,
our researchers started digging into him. And because everybody was ablaze last week that he made some comment, I can't remember exactly the comment that he made last week about the, it looks like this is a witch hunt. Did he use those terms specifically?
He said that it was a counterintelligence investigation continuing on from a false FISA warrant coming from George Papadopoulos, that's what we said from the beginning, and so you can't get any more damnable than that.
Okay. So he said that, and it got everybody excited that maybe we're going to start seeing some justice. So just for grins, our researchers started digging into his background, and it's just unbelievable. I mean, the level of his involvement in the deep state's just pouring out all over the floor. We can't keep up with the evidence coming in right now. So, to give an example, Ellis is hearing another case right now that came back to him on appeal, where the Wikimedia and a number of plaintiffs sued the NSA and Clapper for the illegal surveillance program. And one of the pieces of evidence that they submitted was Snowden's slide showing when all of the carriers like Facebook and Google and YouTube and Yahoo all started sharing data with the NSA. And I won't go into the details of this case, but we've read both the case, we've read the appeal, and we've read Ellis's opinion. And Ellis threw this case out on a motion to dismiss and therefore protected the NSA and Clapper. And Wikimedia appealed it to the Fourth Circuit, and the Fourth Circuit overturned Ellis and sent it back to him and said, you didn't do your job. They did make their case properly, and you need to move forward. So that case is before Ellis again. When it went up to the appeals court, I'll play this game with you. Guess who began representing the NSA and Clapper in the appeal of this case, this Ellis case?
Well, I would think Michael Horowitz or Rod Rosenstein.
Rod Rosenstein. And they added Jeff Sessions as a defendant as well. So Rod Rosenstein was representing Jeff Sessions, the NSA, Clapper, Loretta Lynch in the appeal that's now gone back to Ellis. Now, given Ellis's position where he actually exonerated the NSA and threw the case out, or actually he just threw the case out, and he used some your favorite, the lack of standing. He said all these people, all these citizens of the U.S. are complaining about the NSA's illegal surveillance, didn't have standing to sue.
This is just unbelievable.
No, that just defies common sense.
And this is why Clapper isn't being
It's 30, 40 pages of just claptrap legal gobbledygook that he used. When they appealed it, when Wikimedia appealed it, they got it overturned. Well, the other interesting thing about this case is that all of the co-plaintiffs with Wikimedia, or maybe there were 20 different media organizations, human rights groups, civil rights groups. There was this raft of attorneys that were assigned to the case from all the big name firms, and many of those we now know as deep state firms. They all represented these various groups. So it was a feeding frenzy for the attorneys at the district court level in Ellis's court. Well, Ellis ruled against all those attorneys. So we had all these firms, maybe 10 firms, made their case so poorly in Ellis's court that he overturned all of them. Now, you might think, well, how could they all so uniformly not make their case that they all got thrown out together? Well, now we can see what's going on. These law firms involved with the deep state all play on both sides of the ball. So when attorneys need to dial up a bad argument, they just tell the attorney to write a bad argument. So they write a bad argument, and the judge rules against their bad argument. Very convenient. Or they need an argument that actually makes sense, they tell them to do the opposite, and then do the opposite, and then they give them what they want. So this system is totally rigged, like you say. The decision's made beforehand. And so what we see in this case with Ellis is all these lawyers with all these co-plaintiffs wrote such bad arguments at $1,000 an hour that they gave Ellis what he thought he needed to throw the case out and protect the NSA and Clapper.
Legal, procedural shenanigery.
Yes.
Shenanigans. This is
strategery.
Just strategery. And that's because we don't belong to the American Inns of Court. We aren't esquires. We do not have any title or nobility to represent ourselves. Imagine representing yourself in a court before a judge. They get so mad at you because they think that that's insulting because you're not at their level. But some of them are not lawyers. Some of these judges have nothing to do with law, and technically they don't have to have any prerequisites to sit on the bench as an appointee. So the whole system is corrupt. But let's go back to what you said before. The judges always slow walk things. And what we were seeing with Mueller was he was supposed to slow walk this one for 4 years to make sure Trump doesn't get reelected and that the midterms go bad for the Republicans. What happened was he got so involved pathetically with his plan because Comey had botched it up so bad and continues to shoot his mouth off, and Clapper and Brennan shoot their mouths off all the time, that they're creating situations of perjury, of breaking their own security agreements, on and on and on. So it's such a mess that he had to wrap it up as quick as possible. And as we said, nothing will happen from this. No one will be charged, not even the low-hanging fruit. Manafort, none of that. They may keep his case going in the southern and eastern districts of New York because he did make some bad mortgage decisions and move money from offshore accounts. But that's what judges and politicians do all the time. So when we're talking about this is actually somewhat shocking that he's going to wrap this up early. But we also had predicted that Michael Horowitz...
Who said that, by the way? Who said he was going to wrap it up early? I don't see any of that in what I'm looking at.
Yes, you had said that.
I see cases that can go on for years.
The only reason that we're saying that is because Michael Horowitz keeps saying that they've targeted a date of May 18th for releasing some of the information of some of the investigations he's doing. And if, in fact, that does impact the initial investigation, well, one of the initial investigations, which is the politicalization of the DOJ and the FBI, which is what this is all about, because Mueller is continuing on an FBI counterintelligence investigation with the protection of the DOJ, which is an attempt to impeach the president. What we really have is, if they back off now, then that's much earlier than I would have anticipated, and I would only suspect that that's happening because they are getting caught too much. But now that you have revealed that these three judges and their lip service, their rhetoric, which makes us feel very hopeful, may in fact just be another procedural delay.
You mentioned there were three judges. One was a Trump appointee. We had two people looking into her. Her name is Dabney Langhorne Frederick. And the first telling sign is that her pedigree is definitely deep state. Secondly, she popped up on the 2004 Plum Book, so she's SES. She, in her Senate confirmation hearing, disclosed that she has never written an article on any legal issue, period. So what in the heck is she doing as a supposed scholar hearing cases before our federal courts. So it's even worse than that. We start looking into her resume, and we find out that she worked as a commissioner on the Federal Sentencing Commission with Michael Horowitz. There's even a document where they actually wrote a manual together.
Let's just clarify that, before he became the Inspector General for the Department of Justice, he used to travel around teaching corporations how to basically plead their cases so they wouldn't be sentenced severely, and then he would teach the judges how to create sentencing that would be in favor of corporations. And this is well known, and he became like the number one person doing this in America. So he's the king of crooked judicial sentencing.
And she helped write the manual for that with him. There's even a title page where their names are right next to each other.
So she's as corrupt as can be.
She is a Michael Horowitz disciple.
And she's a tabula rasa. She's a blank slate.
She was pushed through in the judicial nominations very quickly. Given the way they're slow walking so many of these judges, it's very curious that she got pushed through so quickly. And now we know why. She's got a deep state resume.
She's going to be put up for Supreme Court justice. She has a blank slate, tabula rasa. She has all the right supposed qualifications to make her as ethical as Robert Mueller or as James Comey or as these people that they tout because they have had positions that they were placed in that make them look as if they would have to be ethical to be in those positions when in fact it's the exact opposite.
Right.
So right. Tell us about the third judge.
So what we see,
or if you wish.
What we see, I've looked at it enough to realize that he's another whole story. We've got to dig more into his resume, but it's classical. So one of the things that, as an engineer, going back to problem solving, is when things don't make. One of the things I can see in looking at the judiciary is when things don't make sense, it's because we don't know all the factors at play. But as soon as you start to understand what the factors are, then things start to make sense and they fall into place. And so it's as we've researched over the years, it's become easier and easier to see the pattern. And the pattern is what law school they went to. Many of them have gone to Oxford overseas, which we all know now is a CIA recruiting ground for that and the Crown agents. And then we see that they go to certain law firms. Oh, by the way, Fredericks was at Covington Burling, which is where Eric Holder is now, and she also was at Latham Watkins, which is James W. Breyer's law firm that represented him at the National Venture Capital Association, which is associated with Incotel and the CIA. So she's got the perfect pedigree to have been nominated a judge and to been pushed through the process on a bipartisan basis, because anybody in the deep state would certainly want her around, and then they put her in the D.C. District Court, which is the one that would deal with all lawsuits related to Donald Trump. So they obviously needed her. And so we see this passing of the baton from one generation to the next, and they all tend to have the same pattern in their backgrounds. They spend a lot of time with U.S. attorneys' offices, in Longhorn's case with the Senate Judiciary Committee. She worked at the White House. So, I don't know what you can say. I mean, it's just so disgusting to talk about. But it is the pattern. It is what we see now over and over again. Well,
with your help and all the experts with who have worked together with Americans for Innovation, we have basically truly revealed SES as the deep state, shadow government, strong bureaucratic force of 10,000, and the way that they get paid more than any civil servant when they start off, and that this is truly a corrupt system in the federal government. But what people also need to understand is there's an equally corrupt system in the federal, particularly the federal court system, but all the court systems. And we have been doing some exposés on that and showing how that goes back to the Bar Association in the City of London. And people oftentimes think this is a conspiracy. And they thought that what we said about SES was a conspiracy until we found that they actually have an association, and that the Senior Executive Association is, in fact, it's a union. But it's more than a union. It's an insider old boys club college to train them in, just as we were talking about, Michael Horowitz trained them all in sentencing and how to sentence and how to go easy on corporations and never put anyone in jail from a corporation. And these kind of things are taught in what is called the American Inns of Court, which comes from the British 4 Inns of Court, the Lincoln Inn, the Middle Temple, the Inner Temple, and the Fourth Court. But in America, and there you can be called to the bar in any one of these 4 inns in England. But in America, you're only called to the American Inns
of Court.
Of court.
Right.
And that is basically a union, folks. This is a union of judges who are appointed for life, who also, just like SES, can receive presidential awards each year, up to $35,000 bonuses each year because somebody said they did a good job. And so I don't know that we have discovered an SES for the Justice Department, but you've just heard how SES members can be judges and judges SES members. So some of them come in from the get-go and get paid higher rates and still can receive those presidential awards, giving them, huge amounts of money per year. But some of them, the old guard of the court system, they have offshore accounts. Let's just be very clear about that. They also have insider knowledge for trading on the stock market for companies who are being protected by the court system. And they're being protected because they all got together in their little tea club, their dinner group called the American Inns.
They meet every month, by the way, in these different chapters all over the country.
And they have mentors.
We first ran into them. We first ran into them in our patent appeal. And one of our shareholders did a FOIA request and got the names of the judges, and we discovered that they were officers in the Inns of Court named after one of the Federal Circuit judges who was actually sitting. So this is a big ego-stroking enterprise, and clearly they get together and they compare notes. And when you combine the Inns of Court with the Judicial Conference, which is a yearly, I think it's yearly, maybe biannual, judicial conference where all the judges have an excuse to get together and compare notes again, you definitely see an insiders group that where you're invited to play or not play. And this further reinforces my suggestion that in order to reform this, we've got to do away with it, and we need to require that attorneys not be judges and that engineers take over the adjudication of our justice system, and we get back to common law and stop all this nonsense, because it's just been layered with so many layers of opinion and precedent and counter precedent, and truly this system can indict a ham sandwich, and all they have to do is decide to do it, and we citizens are left holding the bag.
I mean, this is just like bankers being brokers. Judges having a union, an association where they get together to discuss. Certainly, you can't tell me they don't discuss their cases. And some of these groups meet on a weekly basis, and they meet in clusters. They meet with mentors and mentees. In other words, it's an old boys club where you are told that your decisions will fall in line with the group or else. Or else is, as you've pointed out, there are these chief judges in each of the districts and appellate courts that determine who gets what case. And the person who determines who gets what case determines the outcome of the case from the get-go before it even starts.
Right.
This is just blatant corruption. I mean, I don't understand how people can't see through this. I'll tell you how I was naive until you...
Well, I mean, I tell you why it carries on is because half of our Congress are lawyers.
Precisely.
That's a rough number, but it's about right.
And they're benefiting from these things. And when they come out and they become lawyers again in corporations who they defend. And they can defend because they built the loopholes into the laws that they helped pass. And many people don't know those laws. And my naivety about law, and since I'm not an esquire, since I'm not a landed gentry, since I do not have a title, I can't even represent myself in a court. Now, I have seen lawyers who were such idiots, they didn't know anything about law. the judge would help them through because they have that title after their name, Esquire. They are, in fact, British royalty. And it is sad to think that we still that we give obeyance to the Inns of Court in England, because this is a type of corruption that is unparalleled. The only thing that I know to compare it to is what we do in America called special counsel, or grand jury impanelment and grand jury indictments. Grand juries are based upon the British Star Chamber, which was to protect the elite and to basically lock up the commoner. We do that in America. It's blatant. It's grotesque. Nobody ever withstands, well, hardly anyone ever withstands a grand jury indictment unless you're one of the very, very top-level deep staters. Like Dick Cheney had 5 grand jury indictments against him. He didn't answer any of them. Isn't that amazing? And that was at the time that he became the vice president of the United States of America. And he was selling, through Halliburton, equipment to Iran during a sanction. This is an open and closed 5 cases against him, but oh no, when a grand jury wants to indict a ham sandwich, they will, but if they want to eat the ham sandwich and dismiss it because it doesn't have grounds, they'll do that too. So they can do whatever they want, and we didn't know this, and you have pointed out so much of this because of your direct experience with it. Another thing you've pointed out is this illegal, and now it's been questioned even in the Supreme Court, appointing of courts within agencies and judges who have never been appointed, ruling those courts, making determinations on regulations as if they were law, as if they were judges. Can you explain a little bit of that? Because every time I hear about that, I think, oh, well, this is how it goes down. It doesn't even get to the court. Most things don't get to the court. They get decided by people
Right.
who are insiders.
At some point, our laws got the legislature was talked into passing laws that were vague, and then allowing each agency to set up its own administrative court, to, ostensibly to carry out the spirit of the law, so that they didn't have to go into as much detail. But what that did is that then empowered these regulatory courts in each agency to basically become separate courts themselves. And just recently, the Supreme Court just affirmed that the Patent Office was able to rule against a person's property out of their administrative court without actually taking it to federal court. So the whole system of regulatory courts that are these judges that we don't elect, we don't appoint, we have no say in who gets appointed to these courts, have now pretty much taken over the administration of, quote, justice in our agencies. So you've got them in the EPA, you've got them in the IRS, you've got them in every agency.
I think that if we close those courts down, those administrative courts, if we pull all federal courts back into the area inside Washington, D.C., the district, the only district that they have control over, and that they are limited to only federal issues, and there are only 8 federal issues. There's only 8 reasons for the federal government to exist. If it isn't one of those 8 issues, it can't go to a federal court, in my opinion. There should be no federal courts in the states, and issues of even income tax, issues of so on and so forth, can still be managed by states. They were set up in a corrupt way to begin with. The Congress has the right to set up courts. But when they were set up, it was a game. Who could get the first federal courts in your own state so that you have your own appointed judges in that state making rulings for that state? And then it got very, very confused. So many people will say America is a corporation and that the federal courts are actually illegal, unconstitutional, that they have no authority over citizens, that we are mixing up the concepts of chartered agencies and or corporations as being due unalienable rights, that they have rights. They don't have rights. Corporations don't have rights. States don't have rights, and the federal government doesn't have rights. Just think about it.
As soon as you start having judges that aren't members of your community and don't have some social accountability for what they're doing, you invite corruption, because the drivers for who wants to become a judge in that kind of situation is the internal pecking order. It's not the citizens. It's not the needs of the citizens, because you have no contact with them. I mean, I dealt with all these courts in Delaware and in Washington D.C. They don't care at all about what's going on in Ohio.
So
it's
true.
all about them.
And they're so capricious. You know, I keep saying that every judge that says, you're not going to do that in my court, any judge that uses the word my court should be immediately impeached. It isn't their court. And any judge that thinks that they, as a federal court or a state appellate court or a circuit court, thinks that they can overrule the President of the United States and the U.S. Constitution and the Congress by making rulings that defy the U.S. Constitution, they should be impeached if found to be false.
And that's the problem. Impeachment is too high of a hurdle, and it consumes. I mean, it has to be impeached at the federal level by the Congress. So how many cycles of hours does it take to impeach one judge in Congress? It's way too difficult to get rid of a corrupt judge in the current system. I mean, we've got to have a different system of accountability, or they just have to get off the bench after so many years. So there's a whole bit different set. If you're actually going to solve this problem like an engineer would solve it, you're going to come up with a solution that could be bipartisan, that could be fair, and could get dead wood and corrupt wood out after a period of time or during the time. But right now, these judges truly are acting like little gods, and whenever they get challenged for fraud, they've pulled out some statute. There's several decisions where judges are not accountable for their own fraud during a case. I mean, it's just out of hand.
There's also laws that say that the esquires, the lawyers who are presenting these things, if they represent the government, first off, any evidence they present that is a government document is truth. Second off, that they think that they're immune from prosecution themselves for misrepresentation. Third, so They act with absolute impunity with complete precocious capriciousness. For instance, how is it that, I mean, if you send a question to the Supreme Court, you can pretty much determine by just reading the question what the vote's going to be, because we know what those judges are going to vote. They were put in those positions because of their opinions. If that is the case, then they are not in any way unbiased. So we need a way to elect these people, and then if they fail the people in their region, and only in their region, there can't be federal courts in states, but if these judges fail, they need to be voted off the bench, and that's
think of the incongruity of that. Think of the incongruity of the image that we have of the justice being Lady Justice with a blindfold and an equal scale, right? That's what we are supposed to believe as the stupid citizens. While the very system that selects judges is partisan and political and clearly corrupt, and yet they're standing behind Lady Justice, it makes no sense.
Well, it's like the imperialists of Britain, they did business with a sword, merchants with a sword. This is justice with a sword, but the justice is blind because she can't see which way the scales have gone, because we don't do it by justice anymore. And there's a sword there because the people with the biggest sword, the biggest money, the biggest lawyers, the biggest esquires win the case because they go right up to be judges, and judges above those judges, judges above those judges, and Supreme Court judges. So what happens here is our judicial system has been overthrown by force, just as our economic system has been overthrown, which we have demonstrated, and our political system, particularly at the federal level, has been overthrown. But we've already given the solutions. Get rid of the administrative courts, make all judges accountable
engineers.
And engineers, make sure they're not even lawyers, and then make sure that they're elected so that they're accountable to somebody.
And lawyers should not be allowed to be politicians, because you can't be passing the law, you can't be making the laws and then being hired to carry out the laws.
And take advantage of the loopholes that you just created on purpose.
Right, that you just created on
the
purpose.
The 13th Amendment, the original 13th Amendment said no lawyers in the Congress and in the government.
Well, that was wise, and why are we not paying attention to it?
The reason they didn't want the lawyers, because the lawyers were all British loyalists in the beginning. All of them. 25 of the assigning members of the Declaration, 21 to 25, were all esquires. They were all lawyers, and they all had been called to the bar in England. Okay, so what we had here, and still have here, is somewhat of an attempt of lawyers and a court system from Britain to move into America, take it over, and completely control it. And basically, it's nothing more than a group of people who think that they're above the commoner because they are lawyers, they're esquires, they are landed gentry, they hold a title, they hold a title of nobility. They believe they're above us. They need to be taken down. And their bar associations need not to be unions preaching the standard bureaucratic status quo. They need to be preaching justice. And they don't need to be working in unions. They don't need to be working in clubs. They don't need to be meeting in clandestine meetings where they are setting the tone of the entire justice system. So you have, again, brought us to an awakening and a realization that's on a much deeper level than what we hear almost anywhere. You won't hear anything that you just said on any mainstream media. That's guaranteed, and almost in no alternative media. So we want to thank you again for your research. I know you've been down in that mine researching this stuff for weeks now. And as you were pulling it up, I must admit, it was very tedious to see some of this stuff because it's like, oh, same old corruption. But when you finally got the leverage point to say, what is really going on here? It's the most insightful thing that Hannity's not talking about this. Lou Dobbs isn't talking about this. Judge Janine. Nobody's talking about the reality of this was a fake headshot and that it is an indication of what is going on, but it is a wrong indicator. What we need to do, as you were pointing out, sit back, relax a little bit, and see how they slow walk this and where they slow walk it to.
Words are cheap, actions are king. And right now what we saw was a head fake, in my opinion.
Beautiful. Michael, thank you for the conversation today. I'm sure we'll be speaking again soon.
Okay.
And thank you to all the researchers there, and tell your friends at Americans Innovation. It's shocking what you guys reveal. It's always a red pill, but we're getting used to taking them. Thanks again, Michael.